Ready, start. In the light of the above, we are of the considered view that the High Court had faulted in affirming the finding of the Railways Claims Tribunal whereunder the claimant's petition had been rejected for non-production of a seizure memo of the ticket and for non-examination of the investigating officer, which is and was the main thrust of argument canvassed by the learned counsel appearing for the railways. This reasoning ignores the consistent judicial line that the absence of formal seizure or witness examination does not by itself negate bona fide travel when other material evidence substantiate the claim. Mere technical irregularities or lapses in procedure should not defeat a legitimate claim under a welfare statute like the Railways Act 1989. A hyper-technical approach which would frustrate the object of providing relief to victims of railway accidents should be eschewed. The insistence on a formal seizure memo would amount to importing a standard of proof which normally is sought for in a criminal trial. Hence, we reaffirm that proceedings under Section 124-A of the Railways Act are not criminal trials demanding proof beyond reasonable doubt, but welfare statutes are governed by the principles of preponderance and probabilities. Once the foundational facts of within bracket first possession or issuance of a valid ticket and within bracket second occurrence of an accidental fall from a train are established through credible material, the statutory presumption of bona fide travel must operate in favor of the claimant. The railways, as an instrumentality of the state, cannot defeat such claims by pointing to procedural imperfections in investigation or non-examination of formal witnesses. To hold otherwise would erode the beneficial character of the legislation and convert a social justice remedy into a forensic obstacle race. It is therefore declared that where an official railway inquiry or evidentiary record verifies the issuance of a ticket corresponding to the date and route of an untoward incident, such verification shall constitute prima facie proof of bona fide travel, shifting the evidentiary burden on the railway administration. The absence of a seizure memo or the inability of the police to preserve physical evidence cannot by itself defeat a legitimate claim when the totality of circumstances supports the claimant's version. This principle shall guide all future tribunals and high courts in construing section 124-A so that the statutory right to compensation remains real, accessible, and consonant with the humanitarian purpose of the enactment. In the light of the foregoing discussion, we are of the considered view that the findings of the Railway Claims Tribunal and the High Court would not be sustainable and would warrant our interference. Hence, the judgment dated 16/1/2023 passed by the Railway Claims Tribunal Bhopal bench and the order dated 15/5/2024 passed by the High Court of Madhya Pradesh at Jabalpur in miscellaneous appeal number 3451 of 2023 are hereby set aside and the claim petition is allowed in part and the respondents are directed to pay a compensation of rupees 8 lakh to the appellants applicant within 8 weeks from the date of this order.